A popular government without popular information or the means of acquiring it is but a prologue to a farce or a tragedy, or perhaps both, by James Madison. Iowa public records and open meetings laws are important because they do allow our citizens to have the opportunity to know what's going on in their government, to know what their elected officials are doing, and to be able to observe that in real time so that they aren't caught off guard or have disputes or concerns as to what's going on. The public information laws are contained in Chapter 21, which concerns open meetings, and Chapter 22, which is public records. Our act, the Iowa Public Information Board Act, is contained in Chapter 23, and that outlines the things that we're allowed to do. But primarily, we're an independent agency that reviews questions and investigates complaints concerning the laws under open meetings and public records. We're going to talk a little bit today just about those portions of the open meetings law and the public records laws that actually have been impacted in the last 6-7 months with the various restrictions that have been put in place since COVID-19 first came to Iowa. So the main chapters we're going to look at in open meetings are 21.3, which is information about meetings of governmental bodies, 21.4, which discuss public notice, 21.7, which is rules of conduct at meetings, and 21.8, which discuss electronic meetings. First off, here's what the statute says. So we've got pre-COVID language on there, but it's actually still the statute. It's been modified somewhat by governor's proclamations. But meetings of governmental bodies shall be preceded by a public notice as provided in the code and shall be held in open session unless closed sessions are expressly permitted by law. All actions and discussions of meetings, whether formal or informal, must be conducted and executed in open session. So that's where we are right now in terms of the law concerning open meetings. You have to give notice, and it has to be an open session unless you have a closed session pursuant to Iowa Code Section 21.5. 21.4, parens 1, parens A through B, talks about how a governmental body needs to give notice. The notice must contain the time, date, and place of each meeting, including a reconvened meeting, and you must also include a tentative agenda of the meeting. That tentative agenda should be drafted so as the public will understand what's going to go on at that meeting. You have to include advising the news media who have filed a request for notice with a governmental body, and you have to post the notice on a bulletin board or other prominent place which is easily accessible to the public and clearly designated for that purpose. That notice needs to be published or actually posted at the principal office of the body holding the meeting, or if there is no such office, at the building where the meeting is to be held. Each meeting needs to be at a place reasonably accessible to the public and a time reasonably convenient to the public, unless for good cause such a place or time is impossible or impractical. And you do have to provide special access to the meeting to persons with disabilities. So what has happened in the last 6-7 months is that, or actually probably more than that now, the question arises, what happens if you're going to have a meeting electronically and you're not going to have an actual location where this meeting is to take place? What if you're having a meeting in a building that's locked? And how do you get access, allow public to access that meeting? How do you post a notice if you're used to posting it at the bulletin board outside right there at the office, you know, at the city clerk's office, inside City Hall, maybe inside the courthouse on a notice board that you have there? What happens if you don't have those buildings unlocked? So that's some of the things that we'll be talking about. What if you have, when they talk about a place that's reasonably accessible to the public, what if you're having it in a room that's too small to allow general admission? Those are the kinds of questions that have come up in the since March of this year. Iowa Code Section 21.7 says that public can use cameras and recording devices. It also says that nothing in the chapter shall prevent a governmental body from making and enforcing reasonable rules. So that authorizes the local governmental body to maybe refine the rules that they've had in place, have different kinds of rules specifically for the type of meetings they're having to hold now, and to be able to have rules that allow those meetings to be orderly and free from interference or interruption by spectators. Now note that it does say reasonable rules. So some of the questions that we have come up is how does that define? There's no specific definition of that. So it's you look at the entirety of the situation and determine whether or not that's something that's reasonable. And of course, as in most concerns or questions or complaints that come up, people have different ideas on what they consider to be reasonable. Iowa Code Section 21.8, subsection 1, provides the information necessary and talks about how to have an electronic meeting. So an electronic meeting, maybe by telephone. Maybe you're going to have an electronic meeting by using some sort of a visual program, such as Zoom or Google Meets. And currently, the language says a governmental body may conduct a meeting by electronic means only in circumstances where such meeting in person is impossible or impractical. And then you have to comply with 3 different items under that. There has to be public access to the conversation of the meeting to the extent reasonably possible. You have to comply with the public notice section. And then this sentence is another one that we've been having questions come up about. For the purpose of this paragraph, the place of the meeting is the place from which the communication originates or where public access is provided to the conversation. So if you have an electronic meeting and you actually, sort of like we do, we actually have staff at the IPIB office. We sit in the conference room. We have a speakerphone and we conduct the conference call from that location. So people from the public can either call in, like our board members call in, or although this hasn't come up yet, we do have the ability to have people from the public physically appear at the location. So the place of the meeting for our meetings is considered the telephone conversation that originates from the IPIB office. Just like in any other kind of meeting, you have to keep minutes of the meeting, and you need to remember to include a statement explaining why that meeting in person was impossible or impractical. Now, starting in March of this year, Governor Reynolds started issuing a number of governor's proclamations. And then they've either been modified or expanded or retracted or changed as appropriately about every 30 days since then. So what we have right now is a proclamation that was initiated on September 18th, and I think September 17th, no, October 18th at midnight is when this current proclamation expires. So sometime probably in the next week, we'll probably have a new proclamation, and it may or may not have the same language in terms of meetings. So under meetings, and this is section 113, the main part of this is I continue to temporarily suspend the regulatory provisions of Iowa Code 21.8 et al. Or any other statute imposing a requirement to hold a public meeting or hearing to the extent that the statutes could be interpreted to prevent a governmental body from holding the meeting by electronic means, provided that the governmental body properly notices the meeting or hearing and includes a telephone conference number or website address that permits the public to participate in the meeting or hearing. The proclamation also suspends those statutes to the extent they could be interpreted to prevent a governmental body from limiting the number of people present at an in-person location of the meeting, provided that the governmental body provides a means for the public to participate by telephone or electronically as provided in this section. So this is the proclamation that has molded that notice and open meetings concept and electronic meetings in such a way to make it easier for local governmental bodies to protect the safety of not only their elected officials and their staff, but the public that attend. So at one point in time, you'll recall we've had limitations of 10, no more than 10 could appear at any meeting or gathering indoors. So that question came up, what do you have? What happens if, you have 5 members on your city council, and then you have a mayor, and you have a city administrator, and you have the city clerk, and you maybe have a couple other people that routinely, city officials that routinely are attending those meetings, and suddenly you're at 10, and you don't have any room for members of the public to physically appear. So this would allow that so long as you have a means for the public to participate by telephone or electronically. What do you do in terms of publishing your notice if the building that's normally open for people to come in, what do you do there? Well, it says that you still have to properly notice the meeting or hearing, and you also have to provide access. So the public needs to know, how do they call in? How do they get on Zoom? You need to have something set up, so especially with like a Zoom meeting where you have to invite the person in or let the person in when they're there, you have to have somebody there to do that. It's somebody who's opening that video door so that the members of the public can come in. And it needs to be contemporaneous access. So I think this is a little confusing, and I actually spoke to the governor's staff because it says provides a means for the public to participate by telephone or electronically. And there's not a requirement currently in Chapter 21 for a governmental body to allow anybody who wants to participate to participate. They can observe, they can audio or video record the meeting, but there's not a requirement that you have to let them speak. So what does participate mean? And what I've been told and what we've been doing is that means that there has to be a method for contemporaneous access to that meeting. So your members of the public that want to, and the media, that want to attend those meetings, they have to have an ability to participate in such a way that they can contemporaneously access the conversation of the meetings. So just, so we started talking about a little bit, but just to make it kind of clearer here, 21.3, there's not a significant impact on the requirements of that. Maybe you have to look at how you do the notice a little differently, but the notice is required still, just like it is in 21.3, and your open sessions are required, just like they are in 21.3. 21.4, no specific changes in requirements. You still have to publish that notice. It has to be published or posted in a place that is reasonably accessible to the public. And you still have to do that more than 24 hours or 24 hours or more ahead of your meeting. So your notice requirements are similar, and just maybe you have to tweak how you go about doing that rather than what you're required to do. 21.7, yes, there's been some instances where the proclamation has expanded the rule policies. So maybe you need to look at, do we need specific rules that just apply to this time frame when the governor's proclamations are modifying the language in Chapter 21. 21.8, the governor's proclamations did not change the language in 21.8, but provided guidance on how to hold a COVID electronic meeting, especially when gathering limitations are in place. So you had some beforehand, it was a question of what exactly is an event that would allow us to have an electronic meeting. And by the proclamation, the event of there being the proclamation is sufficient to be able to do that. Before it said only in circumstances where such meeting in person is impossible or impractical. So that's the proclamations did sort of expand the language on that. So we've been busy, and we've had quite a few cases and calls and cases and complaints and requests for assistance on these very issues. It was sort of rough for the first month. I think everybody was trying to figure out how are we going to make this work, and it required some flexibility and some quick thinking on the part of people. But we're settling in, and I think it's becoming easier and more comfortable for governmental bodies to hold their open meetings and still provide for the safety of their population and for the safety of their elected officials. So here's some of the cases that came up, so just get a little idea of this. The first one is, on all of these notice and access cases involved a gentleman named Eric Henley and the Gilbert Community School Districts. His first complaint came in on April 7th of 2020 and alleged a violation of Iowa Code Section 21.4. He alleged that the meeting on April 6th was held without providing proper notice, and he said on the website. Now, the code does not require that you have notice posted on your website. It says at the location of either the principal office or of the meeting location. But we encourage that if you can put notice in 4 or 5 different places and post it online, that certainly shows a really good faith effort to notify your population of when meetings are going to be held. The board, in this case the school board, responded to the complaint and stated that proper notice had been provided. The board would normally post notice outside the school at the main office of the school district, and that's where that notice was posted. It was posted 24 hours or more in advance of the meeting. The building, however, was locked. So going in to read this notice or maybe pick up a copy was difficult, not impossible. There was on the door of the school, there was a letter that directed people if they had issues that they needed to contact school administration to contact a number. And that, in the school board's position, was that allowed that reasonable access. Before we even got to our board with this complaint, staff had conversations with the school and made a suggestion that perhaps it would be better notice to tape those agendas and notices on the doors, on the glass doors, so that people coming up to the school building would be able to see what those notices are and would not have to make special arrangements to have access to walk inside the building and look at those notices. So in this case, because it was sort of the first one we had, our board ended up dismissing it based on harmless error because they did then correct that, and by the time the board had looked at this complaint on May 21st, I guess it was, by then they had cured that problem. So started off with that. Then on July 13th, the same individual filed a formal complaint, and this was 20 FC 0070. And in this complaint, he had two issues. This first issue was that they were having in-person meetings. However, they were limiting the number of people that could go into the room during the meeting. So the district was allowing the public to present comments during the open forum in person. However, in order to maintain less than 10 people or 10 people or less in the meeting room, speakers had to wait in an adjacent room until it was their turn to speak. Unfortunately, that adjacent room did not have contemporary access to the conversations going on in the meeting itself. So those individuals who were waiting for their turn to be allowed into the actual meeting room were unable to determine what was going on. He also alleged that there was a violation of Iowa Code Section 21.8 because the school board failed to include in the minutes a statement regarding the reason for an electronic meeting. In this case, it was not an electronic meeting because you did have enough people there present in person, and you weren't using an electronic device or system in order for the members to come together. It was only to allow the access from the public. So we just said that it was not an electronic meeting, so they did not need to put the information in the minutes or on the agenda concerning the electronic meeting. However, this one the board did decide to accept because they wanted to be able to assist this Gilbert Community School District in trying to determine how they could go about making this more public and more transparent. So that one was accepted. When we accept a complaint at the Iowa Public Information Board, by statute, it's Iowa Code Section 23.9, we're required at that point in time to work with the parties and try to come up with an informal resolution. That is routinely very successful. We try to determine what is it that we could do to help that governmental body or government body be more transparent. What sort of things can we do based on the complaint made by the complainant, and then both parties, we reach an agreement that both parties can agree to. That agreement then goes to the board and the board approves it. So that's sort of where we're going when we accept a complaint. So that's what happened with number 70. While we were still in the process of dealing with 70, he filed another complaint on July 15th, and this is number 73. And he alleged that there was a violation by limiting the number of people present in the room during the meeting. Again, he was directed to sit in an adjacent room because of a shortage of seats. He, at that point, decided he'd just go home and watch the meeting via Zoom, which he did. So he was not able to attend in person, but he was able to have contemporaneous access to the conversation of the meeting. He again thought that was an electronic meeting because there wasn't open to everybody that wanted to physically attend. And again, it was not an electronic meeting. This one was dismissed because at this point in time, the board was staff was already involved with working with them. Technical difficulties. This has been interesting. I'm still not a Zoom guru, and I would not rely on my ability to be able to properly use some of these various programs that you can use to do video conferencing. In Wall Lake City Council, back in April 13th, had a meeting where they were trying to use the Zoom process. So they had on their notice, they had put two locations, City Hall and also the electronic Zoom link that people could go on to. What happened was it was set up as a Zoom meeting. The mayor and the city clerk and one council member had planned to access that Zoom meeting from locations within the city hall due to the inability of each of them to participate from home. The other council members had planned and were scheduled to attend electronically. However, when they all started logging in or trying to access this, some members experienced difficulty with participating because of what we call equipment and or operator issues. So eventually all the city council members were down at City Hall trying to figure out how they were supposed to use the Zoom meeting. And since they were all there, they just decided that they would go forward and meet in person. So Mr. Bloss came to the City Hall after it started and observed that the council members were physically present. The city clerk in this case stated that they should have postponed the meeting, which is definitely what they should have done, until all the council members had adequate equipment to conduct the meeting. Following this situation, they did acquire the proper equipment to go forward at that point in time from Zoom meetings. They also had an audio recording of the meeting, so anyone who was unable to log in on Zoom, because since they weren't able to get it up and running, no one was able to access the meeting properly through Zoom. So they did have an audio recording. The board at that time decided, well, you know, since this is all kind of new here, we're going to, and since they fixed the situation, we're not going to accept this. They dismissed it as harmless error. Then Jamie Simpson, the 20 FC 0059 case, that one happened after a June 10th meeting. So we're, you know, a little further down the road. We're 2 months later. And they had a Zoom meeting, which people knew how to use. Unfortunately, they weren't inviting participants in until they came up on the agenda. So people from the public that were on the agenda were not allowed to come into the meeting until such time as their issue came up. So they had no contemporary access to any of the other conversations before their actual time. So the lesson there was, if you're going to have a Zoom meeting, make sure you know how to work that so that they get invited in. We did accept that one and then successfully worked with the city of Essex to get that taken care of. Okay, lessons learned. Go through these pretty quick here. The main thing is research the options that will work best for your community. Do you have the equipment and infrastructure to hold a meeting with video access? Do you have your speakerphone, recording device, camera, microphone, or all the other devices needed to conduct that meeting? Remember your community and your audience needs. Maybe your school board, because they teach this, they have all the equipment and everything necessary to do a sophisticated electronic meeting using Zoom or any number of other platforms, but their citizens don't have that. Maybe their internet isn't very fast. Maybe they don't even have internet readily available. How do you notify your community on how to access the meeting? Posting, as we talked about, posting that notice with access instructions on the bulletin board at the main office doesn't work if the building's locked. We also suggest you have a test run of the system and have people from the public or officials try to see if they can log on and get into that meeting. Even if your council or board plans to meet in person, having the remote access available for those members of the public who are at high risk for infection is a way to promote government transparency. So even if you can do it in person, it's still important to remember that there's a lot of people who it's unsafe for them to appear in large groups inside, or they really are high risk, and it's important to think about that. Even though it's not specifically addressed in the state law or in the governor's proclamation, it's really important to think about that. The other thing that's come up a couple of times, if you plan on having a closed session during your meeting, you better make sure to arrange ahead on how to properly conduct the meeting. If you're doing a telephone meeting and you decide, well, we're just going to keep on, but we're going to, tell everybody to leave because we're doing a closed session, there's no way to monitor that. And if you do get them all to hang up, then there's no way to let them know when to come back. So when you return from your closed session to open session, you no longer are contemporaneously accessible to the public. These lessons learned, as I've have labeled them, those are actually on our website. This was part of a this was part of a column that I wrote, and I think somewhere I wrote down when I did it, but July, okay. In July of this year. So those are available on our website if you have questions. Another thing available on our website is under our meeting agendas. We actually struggled the first couple of meetings that the first meeting that we did fully electronically with everybody calling in. And so we developed some electronic meeting guideline or outlines, and those are available on all of our agendas. So if you go on our website, you can look at those. But we have, our rules are, each agenda item will be called in order. Staff will introduce the agenda item. Other parties to the agenda item will be asked for comment, the complainant, then the respondent. The chair will ask IPIB members for comment, and we call on our board members alphabetically. The chair will request a motion and second. Then we have a roll call on every agenda item in sections 5 and 7, or 6 rather. We request that speakers other than IPIB members identify themselves before speaking and only speak when the chair acknowledges the speaker. We ask people to put their phones on mute, not on hold. There are a lot of people who have really unusual hold music. And we ask people to speak directly into their phone and not use speaker phones so that we don't get to listen to all the background information or stuff that's going on. So that's sort of what we've learned and how we've sort of evolved in terms of discussing open meetings under this new way of doing that. I don't know if there are any questions that have come in on that. Let me see, maybe I can make that. What is the limit on the number of people who can attend the meeting? Is it still 10 or is it longer? My understanding is there's no limitation at this point in time. But, however, under 21.7, you do have the ability to have reasonable rules. So if it's difficult for your building to hold a large number of people safely, then, because there's not a mandate, but there's still the recommendations that you try to wear masks, stay at least 6 feet apart from each other, and have proper ventilation so that you don't have clouds of COVID floating around in your meeting. So you do have the ability to do that, but there's not a mandate at this point in time. What does access to the conversation entail? What does access to the conversation entail? Okay, just that they can hear what's going on. It's think of it as though, since there's no requirement that individuals have the ability to speak during a meeting under 21.7, think of it in terms of we've got all these people that are sitting in here listening to us, and they can hear us. And so that's your contemporaneous access. So it's of course better if you have a video clip, because then they can see the whatever physical stuff is sort of going on, and maybe look at physical cues that are going on that you would see if you were in person. But that's not necessarily available, because a lot of places do not have the ability to do that video conferencing programs. But so you need to have contemporaneous access. Not you can go on YouTube and see the meeting the next day. You need to have contemporaneous access. Is that it for? Okay, so I'm going to turn this over to Zach. He's going to tell you a little bit about himself and then go through with public records.
All right, thank you, Margaret. Good afternoon, everyone. Thanks for being here today. As Margaret said, my name is Zach Goodrich, and I'm the legal counsel for the Public Information Board. I'm originally from Grimes. I'm a graduate of Simpson College and Drake Law School. About my background, I've worked in private practice for nonprofits and had a couple different stints in government, both in the legislature and then at the Ethics and Campaign Disclosure Board. And then I landed here at the Public Information Board back in May, so I'm still the new guy in the office. So now we turn to the second part of our presentation today, Chapter 22, Public Records, and in particular, three parts of the chapter, 22.2, 22.3, and 22.4. Get this back on. All right, 22.2 sub 1. This essentially is going over the public's right to examine records and also make copies of them. It talks about how usually examining is free of charge except in certain circumstances, and that the public has a right to copy. And then at the end, it references their Chapter 622, the evidence part of the Iowa Code, which thankfully we have nothing to do with. Then we have the rest of 22.2, which goes on. It provides for some exceptions to this right and a bit more. 22.3 sub 1 talks about the supervision of the records and how the lawful custodian needs to provide an opportunity for the public to come in and examine the records, as well as the opportunity for lawful custodians to charge fees for the production of records that might be requested. It talks about how fulfillment of the request might be contingent on paying fees, and the custodian shall provide an estimate to the requester at the time of the request. That way, if someone is requesting a lot of information from the Department of Public Health that is about the pandemic, say, and then they have the records ready, and then they say, oh, the charge is $37,000, it's good to give them a bit of upfront notice so that they aren't blindsided when the time comes to actually deliver the records they requested. And then this part of the chapter also goes on to discuss having a suitable place for examining the records as well. 22.4, we'll see this is the part of the chapter that has been specifically addressed by the governor's latest proclamation. The rights of persons under this chapter may be exercised at any time during the customary office hours of the lawful custodian of the records. However, if the lawful custodian does not have such customary office hours of at least 30 hours per week, such right may be exercised at any time from 9 to noon and from 1 to 4, Monday through Friday, excluding legal holidays, unless the person exercising such right and the lawful custodian agree on a different time. It's a nice statute. And it just sets a reasonable expectation so that if you have a government office somewhere, people know that they can show up at a certain time and expect to get in and see the records. So that's just a quick overview of part of Chapter 22 and how those laws work in normal times. But of course, as we all know, these are not normal times anymore. So just like for open meetings, the governor has provided for some temporary modifications to these laws in each of her monthly proclamations going back to March. This information is also on our website, ipib.iowa.gov, and on the governor's website and a lot of other websites, I'm sure, as well. I continue to temporarily suspend the regulatory provisions of Iowa Code 22.4 to the extent those provisions require a lawful custodian of records to maintain office hours to receive in-person records requests, so long as the custodian has posted clear direction for making requests in writing, by telephone, or electronic means in a prominent place that is easily accessible to the public. So in the governor's proclamation, only 22.4 out of the entire chapter, it's just that one part that is addressed. But in a way, it touches the first two statutes that we took a look at, 22.2 sub 1 and 22.3 sub 1, because both of those inherently have a right to examine in public, in person rather. And so say a government office is shut down, 22.4, which would normally require them to have hours for the public to come in and examine or request records, that's suspended by the proclamation. But just because the office is closed does not mean that you have no options. So what do? Well, contact the government body. You can do it by email, telephone, or send an old-fashioned letter if you have a stamp handy. Request the records that you seek, plainly, The record custodian might also have some other ways to access the records or submit requests, such as a website. And once the suspension is lifted, once we get through all of this, the in-person access and hours will resume as noted in the governor's proclamation. But until then, the important part is that we continue to provide access. It's just in a different way. And I really want to stress the point of access still being there for the public, because even if the doors are locked and there's a close sign on the door, it does not mean that you don't have access to the public records that you might want, especially now since a lot more people are taking a very significant interest in the workings of the government, since we see it every day on the news about how they're handling this pandemic and then some. So we have a good example, actually. One of our cases of someone trying to get records in this age of COVID. It's Johnson versus the Buchanan County Sheriff, 20 FC 0064, formal complaint we had a couple months back. And Ms. Johnson, she requested a record from the sheriff's office. It was an audio recording. I'm not sure exactly of what, but it was an audio recording. And the sheriff's office dutifully responded the next day, informed her that there would be a $10 fee and she could pay that fee when she picked up the record at the sheriff's office. But that's not the end of the story. It gets a lot more interesting. This office in particular had decided to reopen, but even though they're open, they still have the right to enact reasonable rules that they see fit as it pertains to the supervision of people coming into the office to get records. And the rule adopted by the custodian in this case was that if you showed up to the sheriff's office, you need to wear a mask in the office. Again, nothing out of the ordinary in the age of COVID. And they even were providing masks for the public, just like the Iowa State Bar Association has for us. Thankfully, they've got me covered. So that was the requirement of the sheriff's office. But Ms. Johnson, and I want to point out this is not Margaret Johnson, no relation to her. Ms. Johnson alleged that requiring her to wear her mask would be a violation of her constitutional rights. It was unconstitutional. She said she would pay remotely via credit card, and then that the sheriff's office could have the records sent electronically, either by email or fax. But the sheriff's office in this case does not accept and is not required by Chapter 22 to accept credit cards. So they tried to work with Ms. Johnson, said, hey, you know, if you just want to send in a check, we can send you the CD or flash drive back. That works since you don't want to come into the office. But then Ms. Johnson insisted that she doesn't want to mail anything in, and she doesn't want the sheriff's office to physically mail anything to her. She only wants it sent electronically. But the problem is, like I said earlier, the record requested in this case was an audio file, and it was a rather large one. It was too big to be an attachment in an email, and so the sheriff's office had to produce it on a CD or flash drive, and so you can't send that in an email or via fax. So the sheriff's office said, you can come pick it up with a mask on, or we can mail it to you. And Ms. Johnson refused both of those options. So here, ultimately, there was no violation of Chapter 22. The record was, and probably still is, available for her to pick up as soon as she pays the $10 fee. So because there was no violation of Chapter 22, our board dismissed that complaint. And as you can see on the screen, thankfully, we have not had many examples of complaints that have arisen from this modified procedure thanks to the pandemic. But I would say that that's because most of government across the state is still working and fulfilling requests, even though the process for doing so looks a little bit different. Now, that being said, we have been dealing with several informal complaints, particularly as it pertains to the timeliness of release for requested records. Ultimately, Chapter 22 is silent as to the time allowed for producing requested public records. We noted this in one of our advisory opinions, which states in part, the time to locate a record can vary considerably depending on the specificity of the request, the number of potentially responsive documents, the age of the documents, the location of the documents, and whether documents are stored electronically. The large number of variables affecting response time makes it very difficult and probably unwise to establish any hard and fast objective standards. And this has been upheld and further clarified by both the Court of Appeals and the Iowa Supreme Court in a number of cases, One of the more prominent ones is back in 2013 in Horsfield Materials versus the City of Dyersville. The Supreme Court said, quote, "Practical considerations can enter into the time required for responding to an open records request, including the size and nature of the request. But the records must be provided promptly unless the size or nature of the request makes that infeasible." So while there's no hard deadline that exists, either in Chapter 22 or that has been instituted by the courts, we really want to stress, and we have stressed both in advisory opinions and in general, that this is not an excuse for entities to delay production when they could otherwise produce the requested records in a timely manner. And we have some recommendations for the custodians of records on our website. It's under our FAQs, frequently asked questions. There's a lot of good information on there. The best practices we recommend here is pretty simple: communication between the custodian and the requester. Communication and cooperation can reduce disagreements, maybe even help ensure that we don't have to get involved. It can reduce disagreements over not only the responsiveness of the record request, including the issue of timing, but also the completeness and overall process of the records request, including cost, redaction, and everything else that might emerge. So we have 4 points we'd like to recommend. First, contact the requester to acknowledge receipt of the request immediately and provide a probable timeline that the custodian, probable timeline for record release, excuse me. Second, make additional contacts in the event of a potential delay to discuss possible ways to process the request in a timely manner. Third, work diligently to retrieve and release the records. Fourth and finally, release the records as they are ready, unless the requester has asked that the records be compiled and then released together. And on top of the issue of timeliness, we've seen complaints even before the pandemic with people thinking that they should get records in 10 days or 20 days and think that there is that clear objective standard, when in reality, there isn't. We've also had quite a few cases where people either want to file a complaint or they just have a more informal complaint. And really, ultimately, the information they're not getting from the governmental body isn't a record. They've just been asking questions. So questions about this or that, that's not a record. And so Chapter 22 does not get involved there. So I think that is just about all I have for Chapter 22. You know, we are, yeah.
The person asking the requester is requesting records reviewed by an attorney. Can the municipality charge that attorney's time?
Yes. So Chapter 22, provides for charging the actual costs of production of the record. And it makes a special note to ensure that you aren't charging for every little thing that could technically be considered part of the records request. So if you're in the building making copies, you can't charge for the electricity that you use for the copy machine. You can't charge for the health insurance for the employee for them to be on the clock. For attorneys specifically, this is where we have seen a lot of cases because whether it be parents wanting a lot of records from school districts as they prepare their return to learn plan and they want to know what's going on, well, the school district has a lot of considerations and confidentiality standards they have to uphold. And so they usually call their legal counsel and have them review it. And, you know, we're not cheap. We, for better or for worse, we are not cheap, and attorneys a lot of times can really jack the price up for a records request. But at the end of the day, it is still technically an actual cost. So long as it isn't inflated, it is part of the records request. A lot of people are not happy about that, but that is what the law allows for. And that's that. Anything else? All right. Yeah.
All right, so the question for me is,
So it's kind of follow up on the well-ranking number thing. So if there's not a limitation on the number of people that can the government body establish rules, as well as ask the social
Right, and there's not a lot of clear guidance in the statute, but 21.7 does say you can have reasonable rules, and so those rules are going to be different depending on, like we talked about before, the realities of where this governmental body meets. So as long as they are well thought out and reasonable, I think you're probably fine. Certainly, if you have specific questions, you can contact our office. You can contact me, or you can contact Zach. Oh, the next slide. All right. I should have had that up. Yeah, that's probably a little beyond what we're doing today, but when you ask for electronic records, and this is what we tell people when they call in, well, I want these records, and I want every email that was sent by the mayor for the last 3 years. Well, there's going to be a cost involved in that. And when they hear about the potential cost for that, we tell them, you might want to look at your search terms. What is it you're trying to get? Do you really need every email, or are you looking for a specific topic? And if so, work with the person and try to get those search terms in place.
And I would just add to that, I've seen quite a few cases, kind of going back to the question that was asked of me. If you say, I want all the emails from the mayor over the past 3 years, and if the attorney has to review it, well, then you're going to be looking at a pretty big bill. And so a lot of times we see these governmental bodies work with the requester and say, all right, well, that's a lot of emails. Would you want to try and narrow it down? And usually we do see people say, okay, I want emails that talk about the city's response to COVID-19. I want them from March to June, and I want it only if it's in between the mayor and the city manager. So a lot of people are willing to work with, and that just goes back to the best practices points that I mentioned during one of my slides. Just communicate with the requester, because a lot of times you can really narrow it down, save yourself a lot of time and expense, and save them a lot of expense as well.
I would add to that, and both records and in their meetings, if you have policies, it's really helpful to have that. In particular with records, we have people who say, well, so-and-so got this record for free and I'm being charged this huge amount. So you need to have, it's nice if you have a policy and say, well, here's our policy. It's not, you're being treated differently. We actually have a policy on this. And just make certain that your policy is based on the actual costs. Make sure if you have a policy for how to do your meetings, like we have with our little rules of conduct for our meetings, that they're reasonable, that you're not treating people unfairly. So we certainly recommend that having a policy and making certain that your governmental body has an opportunity to talk about that and adopt it can be really helpful when you have people complaining or wanting something and thinking they're being treated unfairly. Okay, so this last slide that's up tells you how to get in touch with us. And those of you who have not been on our website, feel free to spend some time wandering through. We try to put a lot of good stuff up there. When you go onto the website, you'll notice up in the upper right-hand corner of each page, there is a little gray box. It's our search engine. It's very efficient. That's how I can't remember everything that's on there. So I'll go up and type in a topic, and everything that we've done on that topic will pull up for you. So we strongly recommend that you do that. Call us if you need to be in touch with us. Our email addresses aren't listed here, but basically it's just like your typical iowa.gov email address. So mine's margaret.johnson@iowa.gov. Zach's is zach.goodrich@iowa.gov. So feel free to send us an email.